On this evening's proceedings. I'm Jeff Farnsworth. I'm a partner here at Holding Redlich, and on behalf of the partners of Holding Redlich, we'd like to welcome you here to the 2025 CCIArb Australia Annual Lecture. I should also welcome distinguished guests, of whom there are a number, as well as ladies and gentlemen. I would also like to acknowledge that we hold this lecture, this meeting, on the land of the Darug people, the traditional owners of this land, and I acknowledge their elders, past, present, and emerging. It's a great pleasure to welcome you here for the Ciarb Annual Lecture, which will be delivered by, as I'm sure you know, Professor Doug Jones. I'm not going to read from Doug Jones's resume because it's very long, and if you don't know his many accomplishments, you're probably in the wrong place. What I will do is say a couple of things about his role over the years with CCIArb. Did I mention that I'm the president of Ciarb Australia Annual Lecture? No, I didn't. Okay, well, sorry, I should have mentioned that up front. As well as being a partner of Holding Redlich, I am the president of the Australian branch of the Chartered Institute of Arbitrators. And on behalf of the Australian branch of CCIArb and my counsellors here, it's also a great pleasure to welcome you here tonight. So Doug's history with CCIArb, he became a fellow in 1980. He was chair of the Australian branch between 2002 and 2005. He became a trustee of the global organisation between 2005 and 2008. Global vice president in 2009, global president in 2011, centenary chair in 2015, and became a companion of the Chartered Institute of Arbitrators in 2016, one of only four, I think, Doug, is that right? One of only approximately four companions who hold that honour. Personally, I can say that since I've become the president of the branch, Doug's generosity has been incredibly helpful in allowing me to navigate through the roles and responsibilities associated with that office. I've had the very pleasant opportunity to spend time with Doug and Janet on a couple of occasions, and their friendliness and kindness and support has been really made a big difference to me in this role. So at a personal level, I'd like to thank Doug very much for his guidance and counsel. I'd like to now invite Doug, Professor Jones, to deliver the 2025 Ciarb Annual Lecture. The subject is Diversity of Expertise in Arbitration, Past, Present and Future. Professor Jones.
Well, thank you, Jeff, very much for those very kind words. It is a real honour for me to be asked to give this lecture. I've been a member of the Chartered Institute for longer than the branch has been established. But during the 30 years of its establishment in Australia, it's made a major contribution to the developments of arbitration in Australia. We have now, as is epitomised by this Australian Arbitration Week in Sydney, excellence and vibrancy in both domestic and international arbitration, which is wonderful to behold. And it is a great privilege to be doing this at a time when Gianna Totaro is the CEO of the Chartered Institute. Gianna and I go back a long way, and her contribution to ADR in Australia has been very significant. And Jeff's contribution as president of the branch His outreach across the world within the CCIArb is to be highly commended. I'm going to focus tonight on a topic which is not particularly attractive to lawyers. But it is, I think, important for the future of arbitration around the world and arbitration in Australia. It's the closed-minded attitude in commercial arbitration to non-lawyers as arbitrators. And the topic that I'm going to speak about is in the context of celebrating the Chartered Institute's growth and leadership in the space of international arbitration around the world, opening a debate about the prospect of broadening the role of arbitrators beyond that of lawyers. I'm going to talk about the past, the present, and the future, and to draw some conclusions. I should say that I have prepared quite a detailed paper, but I'm not going to read it tonight, for which you will be thankful. However, at the conclusion, I've got a QR code from which you can download the paper if you suffer from insomnia. The past. I'm going to talk firstly about my experience in the recent past, and then I'm going to move on to the deep, dark past. When I first started practice as a young construction lawyer, more by accident than anything else, I came to know some great arbitrators who were not lawyers. They were engineers, architects, and quantity surveyors. Amongst them, without wishing to regard them as the only ones, I recall Ron Fitch, John Keyes, Ian Cameron, Max McDougall, the father of the judge, and John Morrissey. Some of you may recall those names. They were respected by lawyers and their professional peers alike as great arbitrators who had segued from substantial careers in their own professions through the role of expert witnesses to being arbitrators themselves and having a capacity as arbitrators to run arbitrations in an effective and cost-effective way, as well as, if not better than, the senior lawyers who were also contributing to arbitration. Now, they came, of course, because of my area of expertise, as mentors to me as a young construction lawyer. And they represented an opportunity within the construction industry for arbitration to contribute substantially to expeditious dispute resolution. And as Wayne Martin said yesterday, there was a time in Australia, which I and some of you can recall, when arbitration was actually cost-effective and speedy. And there is no reason why, if non-lawyers could contribute as they did to arbitration, non-lawyers outside the sphere of construction can do likewise. But let's go back a lot further to many years ago. Some of you may be familiar with the 5 books written by the late Professor Derek Roebuck on the history of arbitration, starting with ancient Greece, moving through the Roman Empire to what he called in his last book, the long 18th century. The concept of arbitration encapsulated in those magnificent publications clearly shows arbitration over the centuries sitting outside the court process and providing a great story of human interest in the development of the delivery of justice within civilised society outside the court structure. In those days, and until relatively recently, arbitrators were almost exclusively non-lawyers. Moving to the Middle Ages, one saw in the great merchant fairs of Western Europe the development of arbitration as a means of solving the disputes that those merchants had as they travelled together to the seasonal fairs in which they traded. And fast forwarding to the 1700s from then, if an English man or woman had any experience with the law at all, it was with the community's justices of the peace, who were not lawyers, who were the purveyors of alternative dispute resolution and justice in the English society. Perhaps the key catalyst to the development of what we might regard as modern commercial arbitration was the Industrial Revolution, where there was a need for the professionalisation of arbitration because of the growing importance of technical expertise in the areas of industrial development in the Industrial Revolution. And as disputes scaled in size during that time, arbitrators commenced to charge fees, whereas previously they had provided their dispute resolution services as a service to the community. There is a pernicious and deeply rooted misconception that arbitration was regarded as the ugly sister of court proceedings. But I think that is an overstated proposition, because, as Lord Campbell is reported to have said in the unauthorised report of Scott and Avery, "My lords, there is no disguising the fact that as formerly the emoluments of judges depended mainly, almost entirely, upon fees, they had no fixed salary. There was a great competition to get as much as possible of litigation into Westminster Hall, and a great scramble in Westminster Hall for the division of the spoil." And I think it is that feature which leads to this concept that there was a friction between the courts and arbitration. Within that competitive process, the reason for that friction is obvious. But I think that is an exaggerated issue. Although, to be fair, I think by the modern standards of arbitration friendliness, which we see in the New York Convention and the model law, both ancient Greece and 18th century England certainly left much to be desired to what we presently have in terms of arbitration friendliness. So much for history, of which there is a fair bit more detail in my written paper. I'll turn now to the present. The reality of international and domestic commercial arbitration is sadly far removed from its romantic past. Although industry expertise continues to be rightly touted as a key justification for preferring arbitration to court, in practice, expertise now largely refers to lawyers with a familiarity with the industry in question, rather than to non-lawyers who are actually from the relevant industry. For example, if you specify in an arbitration clause that the arbitrator must have 10 years' experience in construction, This is usually taken to refer to a lawyer with that relevant period of experience in the industry, rather than to a real member of the industry, engineer, project manager, architect, or whatever. And that phenomenon is by no means restricted to infrastructure disputes. But before moving on to what I identify as a real problem at the moment, let's identify where there is not a problem. And in the context of maritime arbitration, commodity arbitration, and sports arbitration, we see a significant ongoing involvement of non-lawyers. Maritime arbitration, dominated, as many of you would appreciate, by the LMAA in London, requires for its full membership at least 15 years in a responsible position in one or more areas of the shipping industry, commercial, technical, or legal. And although now lawyers make up approximately 2/3 of the senior membership of the LMAA, a lot of them being retired judges, non-lawyers still retain a special position in maritime arbitration. Secondly, in the grain industry, GAFTA, whose standard forms dominate over 80% of the world's grain trade, and who had 350 cases in 2003-2004 with awards of the value approaching $500 million, to trace its origins back to the London Corn Trade Association, does not have practicing lawyers on its panels. And it seeks to ensure that any panel appointed by it has a mix of trade knowledge and expertise. And legal representation is permitted only with the agreement of the parties. Sports arbitration commenced largely in 1984 with the establishment of the Court of Arbitration for Sport, has maintained a diversity of expertise over its history. There is a very substantial competitive organisation in London called Sports Resolutions. It has 339 panel members, 33% of which are non-lawyers, and it does not establish a panel to arbitrate a dispute without non-lawyers being part of the panel, chosen for the nature of the dispute, perhaps doctors in doping cases, financial experts in financial fair play cases involving the huge disputes, say, over football, or others who have a relevant expertise in the nature of the dispute. They, of course, appoint the tribunals. The CAS, however, does not, where it's largely party appointment, but sports officials consist of a substantial portion of the tribunals established by CAS. So where is the problem? It is with commercial arbitration, where there is a serious lack of diversity of expertise in commercial arbitration. The legal profession has established and unsurprisingly accepted with enthusiasm the status quo that we have at the moment in domestic and international commercial arbitration. Why is this? Well, I postulate in my paper 3 potential reasons. The first is predictability. There is a perception, certainly amongst lawyers, that non-lawyer arbitrators will lack the expertise to manage the procedural complexity of large matters and be unable to deliver the requirements of procedural fairness which of course is required for an enforceable award. And the consequence of that is that parties and the lawyers acting for parties feel uncomfortable appointing non-lawyers as arbitrators. And that, of course, is a self-perpetuating process, because how do non-lawyers get experience to act as arbitrators if they never get a chance to be appointed? A second potential cause is finality, which, as you know, is one of the features of arbitration, where the opportunity to set aside or attack arbitral awards in other ways is very limited indeed. Now, it has been said in some of the papers about this issue that the potential for non-lawyers is enhanced by the finality of arbitration. That is, the opportunity to attack awards as a consequence perhaps of non-lawyers being a little free with their procedure is lower. But the concept of there only being one bite of the cherry is, I think, also a major detraction by those considering who to appoint as arbitrators when you come to non-lawyers. Litigants aren't prepared to take the risk of a non-lawyer when the problem of there being finality is carefully considered. And a third potential cause is the lawyer's congenital lack of creativity in terms of thinking about different ways of doing things. It's not the done thing to appoint non-lawyers as arbitrators. Certainly, that's the legal view of life. And I really mean no criticism of my fellow practitioners, because in my role as an arbitrator, as a party-appointed arbitrator, it has been my responsibility to choose a chair in conjunction with my fellow co-arbitrator, also party-appointed. And I am quite proud of the fact that in all the arbitrations I've had where I have been party-appointed, there has been success between myself and my co-arbitrator in finding a chair without it having to go to an institution which is more generally regarded as a lottery. And I'm not immune to that issue. The issue is, can one take the risk of appointing a non-lawyer as a chair? How will that process successfully evolve? Now, just to take an example of one of the issues which emerges when you have, as arbitrators, eminent purveyors of justice, such as retired Court of Appeal and Supreme Court judges, but who have no knowledge of the particular area, the subject of the dispute. We have a recent horrific example of what a lack of expertise can do to arbitration. And it is, of course, the P&ID case, where the English court overturned a multi-billion-dollar award against Nigeria on the basis that the entire process had been corrupt. Firstly, the contract, the subject of the dispute, was procured corruptly, and then Nigeria's lawyers were corrupted to throw the case. Now, I must say that despite Sir Robin Knowles' many pronouncements since he gave his judgment in speeches at arbitration conferences, where he said he thought the tribunal should have confidence in itself to question why the advocacy was so inadequate for Nigeria, in my view, if those arbitrators had the faintest idea of how the oil industry operated, they would have recognised the contract that they were arbitrating was clearly a sham. No one familiar with the oil industry would have believed that that contract could ever have been a commercial arrangement of any credibility. And that raises the question of the impact on the legitimacy of the arbitration process by parties leveraging the lack of expertise of a tribunal. So turning now to the future, in my view, we should do something about what has been lost, because there certainly has been something lost when one looks back at the history of arbitration. How could we regain what has been lost? Well, in my view, it is clear that there is a substantial loss of good decision-making, or perhaps to put it slightly differently, better decision-making that could be achieved by the introduction of diversity of expertise. We have in the arbitral community a very active debate about diversity. The LCIA, AKICA, and other arbitral organisations strongly encourage diversity in the areas of sex, gender, race, nationality, ethnicity, sexual orientation, age, disability, religion, geographic location, and social and professional legal backgrounds. No mention at all of diversity of expertise. Professor Janet Walker, who I'm proud to have as my wife, when she gave the annual Clayton Utz University of Sydney lecture this year in the Federal Court, drew attention to the value of the way in which collective intelligence can be impacted by diversity within tribunals. And that proposition impacts, in my view, why we should be considering diversity of expertise within tribunals, because the value of their contribution to decision-making can be very significant indeed. One has to just pause momentarily to recognise the obvious, and that is, in almost every arbitration in which I've been involved, expert evidence is called for some reason or other. And actually managing and understanding expert evidence is a major challenge for arbitrators. There are ways, of course, in which expert evidence can be more usefully obtained than in other cases, particularly in the context of party-appointed experts, but the capacity of tribunals to understand and parse the issues involved in expert evidence is always a challenge. And where a member of the tribunal is a non-lawyer, there is a capacity to add great value to the decision-making process. I have two recent examples myself of that value. Both party-appointed arbitrators, lawyers with the imagination and creativity to get their clients to agree to have a non-lawyer as a party-appointed arbitrator. One was a hydroelectric dispute involving turbine performance. Well, pretty complicated question. There was an argument about whether there was more than appropriate vibration in the turbine. And I was confused, I must say, when at a site inspection, the turbine was run up and down with the tribunal standing on top of it. And I couldn't really detect any vibration. But that, of course, didn't affect the evidence that we had from the experts about how the vibrations were going to fundamentally destroy the capacity of the turbine to perform. We had a female engineer as a member of that tribunal, the first female president of the American Society of Civil Engineers. And the value she added to our consideration of the expert evidence about this turbine performance was just central to our consideration of the dispute. Sadly, she's passed away, taken too early from the profession of international arbitration. The second example, with the chair of the tribunal being in this audience, was an oil concession accounting dispute where the tribunal had to reconstruct hundreds of entries in the accounting records between the concessionaire and the country involved over a period of over 10 years. We fortunately had on the tribunal a quantity surveyor whose contribution to the numeracy of the tribunal was quite extraordinary. And that emphasised to me how there can be much better decision-making by a tribunal when you have at least one person on the tribunal who has a different level of expertise to what a lawyer has, however specialised the experience of the lawyers might be in the area of the industry. So, what can be done to regain the value provided for hundreds of years by non-lawyers to arbitration? One of the problems is party appointment. Now, that is a cornerstone of autonomy, party autonomy. In many ways, I think party autonomy misdescribes the autonomy that one is really looking at in arbitration. I think in most instances it's really lawyer autonomy, where parties themselves don't make the decisions. They do sometimes, but that's not always the case. But party appointment dominates the international scene in terms of three-member tribunals. And the risk of appointing as a party appointment a non-lawyer, and then the risk of the two party appointed arbitrators choosing a non-lawyer as the presiding arbitrator is where the issue arises. Sort of harking back, of course, to the English sports resolution process, they don't have that problem because it's institutional appointment where they choose the people they think are appropriate for that particular dispute. But I think the situation needs to move a long way, and it's got no sign of doing it, from party appointment to institutional appointment in the international and domestic scene where party appointment is the name of the game. Not always the case with sole arbitrators, of course, because it's rarer for two parties to agree on a sole arbitrator than for institutions to appoint them. So institutions have a clear opportunity to do something in the space where there's a sole arbitrator position. But it involves changing the perspective of the users of arbitration, their lawyers, arbitrators themselves, and very importantly, I think, arbitral institutions. For them all to recognise that there is something we have lost in the decision-making process where lawyers dominate the role of arbitrators. But there are some ways in which this could be redressed. And I think that the Chartered Institute has a central role to play here, because as you know, the Chartered Institute is unique worldwide in being a learned society, not looking itself to make money or continue to survive from dominating appointments to arbitral bodies. like the ICC or even AKICA. The Chartered Institute sits as an accrediting body and a learned society with 19,000 members around the world. You can't buy membership of the Chartered Institute. You have to earn it by examination. And so the Chartered Institute itself offers both training and accreditation to non-lawyers, and over half of our membership are non-lawyers. The presumption that lawyers must have the knowledge of the law to be regarded as potential arbitrators is, I think, a conceit. Non-lawyers can develop the procedural ability to actually run effective cases, as they did in the past. Life is complicated, of course, in the environment that we are at the moment in terms of procedural fairness. But to think that every lawyer has the capacity to deliver procedural fairness is itself incorrect. And lawyers being good arbitrators is a matter of experience and training as well as non-lawyers fulfilling that role. The view that users of arbitration had over the centuries that non-lawyer expertise was a central feature of arbitration has been lost. But we do see, certainly within the infrastructure space, in addition to the training and accreditation that the CCIArb can offer, an opportunity for non-lawyers to demonstrate and practice adjudicative skills, because we see it in adjudication. Adjudication, statutory adjudication, wiped out domestic arbitration to a large degree in Australia and England and other places, because by then domestic arbitration had failed to meet the needs of users, too expensive, too lengthy, and not really as effective as adjudication. And the adjudicators in Australia, in the UK and other places in the common law world are usually, not always, but usually non-lawyers. And adjudication has changed the whole way in which some dispute resolution is done in some common law jurisdictions. In addition to that, the introduction in the infrastructure space of dispute boards enables non-lawyers to very substantially contribute to solving project problems, usually with a lawyer as a member of the dispute board. But that accreditation in the minds of the industry participants of non-lawyers as having the capacity to be adjudicative is provided to a degree by the dispute board concept. So within at least the construction space, there are opportunities beyond the CCIArb for people who are non-lawyers to demonstrate their adjudicative skills so that users and lawyers can make judgments about their potential ability. So in conclusion, commercial arbitration has failed in recent years to avail itself of expertise which has historically provided real value to the process. The legal profession's dominance of arbitral appointments has been pervasive and continues with the support of the mainstream arbitral institutions. It is time, I suggest, for the arbitration community to recognise that this undermines the legitimacy of the process, and we should take active steps to remedy the situation. This is an issue of diversity, fundamental to the process and the quality of decision-making in commercial arbitration. And it's not good enough for the legal profession to perpetuate the conceit that only lawyers are capable of delivering enforceable awards of real determinative quality. Solutions are available. May the debate flourish. Now you can pick up the paper from that QR link if you need help with sleeping.
Did you want to take questions?
Yes, I'm happy to answer questions for a short while.
I would love to ask a question. Thanks, Doug. I always find listening to you incredible, but that really resonated with me. I am a non-lawyer, and arbitration, I hope, is one day in my future, so thank you. I am really proud, as you know, I chair the Society of Construction Law in Australia, and we several years ago had a diversity problem in our events, and we did actually write a policy that included diversity of expertise. So I'll take the hit for that, but I think it's made an incredible improvement to our events and the thought leadership that comes out of those. One thing I did want to ask, I guess in my career history, I have noticed that there's a call for change, and that's happened for some time in various aspects of the community and society. And in my experience, mandates have been what has changed that. Do you ever see that there's a place for a mandate to come across in this kind of space?
Well, I think your mention of the Society of Construction Law is very valuable, because in the construction space, in the infrastructure space, it is the only organisation that combines lawyers and those in the business, and that is very useful. And I'm really proud to hear what you say about the recognition of diversity. That's diversity of expertise for the organisation.
For the events.
For your events.
Yes, correct.
But to answer your question of a mandate, from where will the mandate come, is my question. I'm not convinced that without the support of the arbitral organisations, there will be a momentum within the legal profession to expand the opportunities for arbitrators beyond lawyers. I'm not suggesting that would be a sort of positive decision-making process by lawyers, but why would they bother? I mean, it's just, there's so many people wanting to get into the game of arbitration that increasing the competition by a whole raft of people who aren't lawyers sort of just runs against the grain. And therefore, it is unlikely, I think, that outside the arbitral organisations, one will see a mandate for that. Now, the enthusiasm of arbitral institutions for diversity of sex and diversity, particularly of nationality, has been great. It's had a huge effect. Could we possibly encourage arbitral institutions to pick up this challenge? It would be great if we could.
Thanks very much, Doug. I'm Christian Maley. I gave a paper at the Society of Construction Laws conference a couple of years ago looking at this difference in construction costs between common law and civil law jurisdictions. And part of my thesis was that one cause of this is that in common law jurisdictions, the legal profession and also the profession of management has generally a higher status than in civil law jurisdictions, and the professions of engineering and so on, and technical disciplines have a relatively lower status in English-speaking countries. I wondered if, in your experience, there is a difference in the prevalence of non-lawyer arbitrators in civil and common law jurisdictions, and if we can learn anything from that.
I'm not sure that there is. There's recently been established a new organisation called the Construction Arbitrators or something. And I was talking to Ed Corbett, who's been behind that process, and said to him that I was giving this paper and I was going to try and encourage the recognition that we needed more non-lawyers in this space. He said, "Oh, we've got 3. Well, and this is FIDIC based, basically, and FIDIC is very much an international organisation, so I'm not sure that it is different. I mean, the civil law arbitrators tend to be more dominated by professors than practicing arbitrators. Not so much, but they're not. They're still lawyers. So that's not, I think, it's not a divide that I've noticed, unfortunately.
Doug, I had one question perhaps. We seem to accept that awards often need to resemble judgments written by judges. Do you think if non-lawyers were encouraged, well, the enforceability of an award written by a non-lawyer, who might be an engineer or a doctor or something, who just cuts to the chase and says, I've heard the argument, you know, I've made this technical assessment and I think this side wins and this side loses. Do you think that like a staccato non-legal award would have problems with enforceability?
Well, it depends who's judging that. I mean, it's a question here in the context of your question as to whether a straight, simple award would be regarded by a supervising court as adequate reasons, for instance, would depend on the breadth of vision of the judge, I would have thought. But harking back to my history, the awards that Max McDougall wrote were better written than most of the awards written by lawyers. They really were. Now, that's not to say that engineers and architects and financial planners and others should try and emulate that level of written judicial product. But I think it would depend on a recognition. As Michael Mustel often said, and as a number of English judges said in the past, arbitrators are appointed to decide disputes and not to get them right, necessarily. So it would depend, I think, on the enthusiasm of courts to embrace this process. There is, I think there was a case in Victoria some years ago where it was said by the court that a different standard needed to be applied to retired judges as to other arbitrators, and they expected retired judges to produce much better awards than the others. Now, that could be applied perhaps more broadly.
No, he did. I know the case.
Well, thank you very much.
Good afternoon. I'm Ian Robertson. I'm a partner and the chair of Holding Redlich. I'd like to conclude this session by making 3 brief points. Firstly, Holding Redlich is delighted to be hosting this function today, and we've hoped you've enjoyed it and will enjoy what's still to come. Secondly, it's my honour to thank Professor Doug Jones for his address, which we'll agree, I think, was both thoughtful and thought-provoking. I think it's commendable that a global leader of this profession is willing to challenge us to look at better ways of doing things and to really have a call for action for greater efficiency, better outcomes, greater value, etc. I'm not predominantly a litigator, but I've done a lot of litigation in my career, and I think it's fair to say that even the largest corporation today, faced with the thought of commercial litigation, will really recoil in fear, knowing what it's likely to cost, how long it's likely to take, and that the outcome will be at best unpredictable. Commercial arbitration should provide a very desirable alternative. And partly, I think, or in part, as lawyers think about this issue, we might give some thought to the needs of our clients and our own reputation as essentially the guardians of the process. Please join me in thanking Professor Doug Jones for a fabulous address. And my third duty is to say, please stay and have a drink. Thank you.